I'm Robert Henry, president of Oklahoma City University, former Chief Judge of the United States Court of Appeals for the 10th Circuit, and former Attorney General of Oklahoma. I was privileged to serve at the request of all parties on the Citizens Advisory Committee to work on the matter we shall discuss today. Today is a historic day for the great state of Oklahoma. Chief Pushmataha, the Indian general, a legendary chief and leader of the Choctaws, as well as the legendary Chief Tvshka of the Chickasaws, who led by example, would be very pleased with the cooperation and resolution of these important issues that we discuss today. Both of these great leaders fought under the flag of the United States as allies in the War of 1812, and significant real estate in southeast Oklahoma is named for them. And on this day, Governor Fallon, I would imagine that your predecessor, the late Oklahoma Governor and Senator Robert S. Kerr, is especially smiling on us. Because of his vision and his dream and his leadership, which began in the 1950s, Oklahoma became an example for the nation for how to successfully develop and manage our state's water and resources for the good of all Oklahomans. Land, Wood, and Water is the book. Ed Martin tells me it used to be required reading. It should be again. The dream that Kerr had continues today with these visionary leaders who are gathered before you. Because today, again, we show that cooperation and unity achieve so much more than conflict and division. I'm proud to announce to you that the state of Oklahoma, the Choctaw and Chickasaw nations, and the city of Oklahoma City have reached an agreement that settles long-standing water disputes, establishes a framework for future cooperation and conservation, and provides certainty for water resource management within the tribe's historic treaty territory in south central and southeast Oklahoma. The leaders you see before you, Oklahoma Governor Mary Fallon, Chief Gary Batton of the Choctaw Nation, Governor Bill Anoatubby of the Chickasaw Nation, Oklahoma Attorney General Scott Pruitt, and Oklahoma City Manager Jim Couch are here to represent the achievements of their respective governments to reach this historic agreement that not only solves problems of the moment, but will have lasting impact far into the future for future Oklahomans. We are here today not only to celebrate this momentous achievement, but to provide you with information, lots of it, about the agreement, and especially to answer your questions from several of the experts who've been working diligently for the past 5 years on this very important problem. Before those legal and scientific experts who've been gathering around the mediation table for the past 5 years come forward, I would like to ask each of the state leaders that I have named to come forward and make a brief statement to talk about what part of the settlement agreement most affects them or that they're most interested in, and to give you their views on these important provisions. And after those statements, I will ask Judge Mike Burridge to come and moderate a panel of experts who worked on the day-to-day crafting of this agreement. We will begin with Governor Mary Fallon.
Congratulations, Governor. Thank you so much, President Henry. It's a great pleasure to be here today, and welcome to everyone who's come to such a very historic occasion for the state of Oklahoma, an agreement between the state of our citizens, the Chickasaw, Choctaw nations, and certainly the city of Oklahoma City. This is truly a very important event for our state. We all understand the importance of water in sustaining life, and as it is the economic engine that drives growth in our state. By entering into this agreement, we've chosen cooperation and collaboration over conflict. Having a sufficient and reliable supply of water is essential for life, economic development, manufacturing, recreational activities, and important industry sectors like energy and agriculture in our state, just to name a few. Under the agreement, the state will continue to exercise its authority to manage and to protect water resources in Oklahoma. This way, existing uses of water remain secure, and it provides certainty for future development. The agreement also allows the Choctaw and Chickasaw Nation to have a voice in specific proceedings addressing water resources within their treaty territories. The agreement fully resolves the state's debt to the federal government for the consideration for Sardis Lake, which will also ensure that Oklahoma City has a reliable water supply while providing a standard to protect lake levels in Sardis, which is something that we all agree is very important. We now have a mechanism that will be in place to collaboratively address any possible out-of-state water use if out-of-state water use is ever authorized by the legislature. It will provide protections for the source basin and region while ensuring the entire state benefits. This agreement also strengthens our governmental relationships based upon common interests of the state and the Choctaw and the Chickasaw nations. I'd like to applaud the determination, the visionary leadership of the Choctaw and Chickasaw Nation. Thank you. We appreciate what all the parties have done. Certainly the city of Oklahoma City has been highly engaged, along with the Attorney General's office, in helping us reach this day and reach an agreement that benefits everyone. Thank you so much, and congratulations to all the parties involved. Congratulations to the state of Oklahoma. This is a big deal for our state.
Next, Chief Gary Batton of the Choctaw Nation. Congratulations, Chief.
Well, first of all, halito, and greetings from the Choctaw Nation of Oklahoma. And first of all, I want to say just thank you to this great panel up here of leaders who has really set an example of spirit and unity and protection of a great resource we call water. And you know, this process we call mediation, it's a wonderful process. It's a difficult process. But you know, at the end of the day, we all came together in the spirit of unity for the betterment of southeastern Oklahoma, central Oklahoma, and Oklahoma as a whole. One of the things to me that was really important is to make sure that we kept protections in place for all of the water. Protections such as a good lake level management plan for Sardis so that the lake cannot be drained. We want to make sure that that is protected. Protections for southeastern Oklahoma because there now will be a certainty of water for our area as well as central Oklahoma. Protection of our streams because there will now be a certain amount of water in the Comiskey River Basin. Protection that natural conservation measures will now be in place so as to not waste water. Protection because there is now an allocation of water for fish and wildlife. And because of all these protections, it gives us certainty of water for our area and for the state of Oklahoma, which makes sure that we're going to continue to have economic growth and viability for southeastern Oklahoma and for the great state of Oklahoma. And so I'll leave you with this, just a chapisa la chiki, which there is no goodbye in Choctaw, but until we see each other again. Yako ki. Thank you.
Thank you, Chief. And now Governor Bill Anoatubby of the Chickasaw Nation.
Good afternoon, and thank you very much. Wow, this is a day in history that we can remember. This is an historic agreement for us, for the Chickasaw Nation, the Choctaw Nation, the state of Oklahoma as a government, the city of Oklahoma City, but for all Oklahomans. Because this agreement is based on the common interests of the people we serve as leaders of our respective governments. Everyone involved in this process has unique responsibilities. As tribal leaders, our responsibilities are deeply rooted in history. While we've been sovereign since time immemorial, sovereignty is something we should never take for granted. As tribal leaders, we have a duty to engage in this process and exercise our rights as sovereign nations to protect the interests of our people. When we protect the interests of our people, we are also protecting the interests of those people who are around us, particularly when it comes to water. Just as Chief Batton and I have the responsibility to protect the interests of Chickasaw and Choctaw people, we know that Mayor Cornett, Governor Fallon, each have a responsibility to protect the interests of the people that they serve. At the onset of this process, it's probably safe to say that each of us was focused on the needs of our own constituents. As we worked toward or through this process, it became increasingly apparent that we would need to look at a much, much bigger picture. As we became more involved in the process, we came to better understand that the people we serve all have common interests. We all understood that we have a responsibility to manage our water resources in a manner that will meet the needs of all Oklahomans. And we also understood that in order to do that, we would have to find a way to resolve our differences. It's a credit to Governor Fallon, to Mayor Cornett, and the people who work with them that we were all able to work together to find ways to resolve our differences. Through this settlement process, we were able to find a way to preserve and protect the water resources essential to economic growth and quality of life in south central and southeastern Oklahoma, while still providing water needed to meet the needs of the people of Oklahoma City. Mayor Cornett and Governor Fallon also deserve much of the credit for the fact that this agreement does more than resolve past differences. It provides a framework for cooperation and collaboration. They understand that none of us lives in isolation. Our actions have an impact on those around us. Therefore, it is essential that we work together to exist in harmony, one with the other. We should strive to complement one another as we work toward common goals. Under this agreement, the state will continue to exercise its authority to manage and protect the water resources throughout Oklahoma. However, as we move into the future, our nations, the Chickasaw and Choctaw nations, will have a meaningful and active voice in the management of water resources well into the future throughout Oklahoma. However, as we move into the future, our nations will have a meaningful and active voice, and we wish for that, and now we have it. This agreement is a win for the entire state because it provides a foundation for a deeper relationship based on engagement, collaboration, and cooperation. Under the terms of this agreement, we will be able to work together in a spirit of unity and cooperation to manage our vital water resources. This offers the very best opportunity to manage those resources in a manner that will help ensure a strong economy and a thriving natural environment for our children and grandchildren, so we can expect the benefits of this agreement to last for generations to come. I thank the other members of this group here today. I thank the group that toiled often, many hours and days to come to terms on this agreement. And you will see those people when they come in here just in a few minutes. But with these people working together, they were able to find this common ground. And I'm so thankful for their work and the effort they put forth, because it's benefiting all Oklahomans. Thank you.
And now, Oklahoma Attorney General Scott Pruitt.
Well, thank you, President Henry. It is wonderful to be here with you today. Part of the danger of batting fourth in a four-team lineup is that sometimes there's danger of duplicating some material and some information. So I endeavor today to share some important aspects from the Attorney General's office in our view of the historic nature of this settlement. And I don't want to overlook, and I don't think you should overlook, when you hear from this podium today that this is an historic accomplishment, it is in fact an historic accomplishment. Water litigation, typically across the country, when you engage in this type of exercise, lasts decades. And this journey began 5 years ago this month. For us together, 5 years on the anniversary of this litigation starting, to announce to you a settlement of this magnitude, of this importance, of the duration of resolving issues both historically and in the future is quite an historic accomplishment. And I want to say to each member on the panel up here with me today, it took a great deal of commitment and perseverance. These were weighty and difficult issues that we have dealt with, and we did so with great collaboration, great goodwill, and when that happens, great results can occur. And I want to commend the rest of the members of the panel and the settlement discussions we've had for the last 5 years. Two things that I'll emphasize to you that I think are very, very important. One, from a regulatory perspective, this type of litigation, this type of adversarial setting creates disruption for those that have permits in the marketplace today. So the regulatory process with existing permit holders can create great uncertainty with respect to the future. And so when litigation goes on for decades, people are impacted adversely, both existing permit holders and those in the future. So we avoided a lengthy, costly, and disruptive process as it relates to the regulatory impact on Oklahoma. And as already been stated, the Oklahoma Water Resources Board will continue to be that agency, that entity at the state level that engages in water allocation, permitting authority, and there will be a significant voice that has been given to both the Choctaw and Chickasaw nations to ensure that the treaty territory as well as the state of Oklahoma takes into consideration needs and concerns of folks in that area to ensure good water usage into the future. And so that is a very important part of this process. Both the state and the nations, I believe, achieved great outcomes with respect to that process. And then secondly, it also dealt with future issues. It has been discussed often at the Capitol, as you know. It's been discussed often in the state about the possibility of out-of-basin transfers or out-of-state transfers. And I think each person here today would say to you that is very uncertain with respect to the future, whether that's ever going to be authorized. But when you engage in transactions in the business sector and when you engage in negotiations of this sort, as we did in the litigation, you have to anticipate. You have to look forward and plan for that possibility in the future. We have done that. We have created a mechanism in this agreement that ensures that there is collaboration and discussion about that very momentous decision to perhaps sell water out of state or to transfer the waters out of basin. So I believe that we have done our job. As leaders for both the state of Oklahoma and the nations that are represented here today, we have worked diligently on behalf of those individuals that we represent, and I think good outcomes have occurred for our people, both of the Choctaw, Chickasaw Nation, as well as the state of Oklahoma. And I really believe that we should celebrate that today. Thanks very much.
And Oklahoma City Manager Jim Couch.
Thank you, Judge, Mr. President, General. I'm never really sure what to call him. The City of Oklahoma City and the Oklahoma City Water Utilities Trust is very pleased to be a part of this historic agreement. It's been a long journey, but through this journey, we always remain hopeful, and we remain hopeful for a number of reasons. First, because of the professionalism of the groups we're involved with. They were always dedicated to the end. Secondly, because of the listening skills. I know that seems strange, but I don't know how many times throughout the process people would say, oh, now I understand. Now I get where you're coming from. And thirdly, the art of compromise was done through this. Everybody gave up something to come up to this agreement. And I really do applaud everyone for being a part of all of those, bringing all those traits to the table. The Oklahoma City and the Oklahoma City Water Utility Trust will get some water out of this agreement and compromise. Water will come from Sardis, ultimately, to Lake Atoka, and ultimately up to Lake Stanley Draper. But it's just not for Oklahoma City. It's also for other communities in the metro area. Oklahoma City provides either all the water or partial water to Norman, Moore, Edmond, War Acres, The Village, Piedmont, Yukon, Mustang, El Reno, Blanchard, and I'm sure some others. They will all benefit from this. We also provide water for communities up along the Atoka pipeline. Communities and rural water districts in that part of the state will also receive benefit from this agreement. We have also provided set-aside water for the area around Lake Sardis. So they will have the benefits of water through this agreement. So this isn't just about Oklahoma City. It's about a much greater area than that. And we're going to take that water while being respectful to the Kiamichi Basin, and particularly Lake Sardis. We've agreed to a lake level management plan that's about as strong as lake level management plan that's maybe ever been put together to protect the level the best we can. Chief Batton has explained to me that he can't have a situation where Lake Sardis is drained and the lakes in Oklahoma City are full. That's an untenable situation for him. I've tried to explain that, it's not real good for the lakes to be empty in Oklahoma City and the lakes in Lake Sardis to be full. And I think we struck a compromise where we'll be able to recognize each other. We're going to be talking through this process and get some water for the metro area and to feed our future growth, but also be respectful and keep as much water in Lake Sardis as possible. And we'll also have some minimum stream flows that'll be in the Kiamichi River. I think it's really a win-win-win situation for everyone. Conservation is also a key part. Oklahoma City has introduced conservation efforts. A plan was adopted in 2012, and that is incorporated. Just because there's water, that doesn't mean we shouldn't be using it wisely. And so we have these provisions, and when we get in drought provisions, we can only access some of the water down in Sardis if we do more conservation in Oklahoma City. It's a good plan for all. I want to thank Mayor Cornett and the Oklahoma City Council for their support to this agreement. They've been there all the time. And I want to give a special thanks to Councilman Pete White. Many of you may or may not know Pete, but Pete is passionate about water. He's been on the council off and on for over 30 years. He was on in the 80s. He quit for a while, and he's been back now for plus 10 years. And most of the time on council, he's been chairman of the Water Trust. And he has a very strong passionate. And he can't be here today, but he was a strong supporter for getting this to the end. So thank you all, and I really appreciate being part of this historic moment. Thank you.
And now I'm going to ask that you give up your chairs and bring forth a panel of experts and scientists and lawyers. That's what is coming. You're going to get the people who have worked with it every day. And I'd like to call upon Judge Michael Burridge, a friend of mine. We used to be federal judicial colleagues together. I'd like to call upon him to introduce the panel and to also moderate.
Thank you, Judge Henry, and I really appreciate you referring to us as experts, Let me give you a little context about how this all came about. In 2011, the nations filed their lawsuit in federal court that dealt with the regulatory rights of the state of Oklahoma with regard to water in southeast Oklahoma. Shortly after that lawsuit was filed, the state filed a lawsuit in the Oklahoma Supreme Court, which is called a stream adjudication. That lawsuit was removed to federal court, and both of these cases have been under the jurisdiction of Judge Lee R. West. And I'd like to compliment Judge West in this process. He's been patient with us and allow us to engage in this mediation process, and has given us the tools and time that we need to reach this historic settlement. The mediation process was over a 5-year period. There would be mediation session meetings, most of them at my office in Oklahoma City. They would be attended by these gentlemen and others. They would last 1 to 2 days at a time, and this has gone on for this 5-year period. And during that 5-year period, we would take these issues that needed to be dealt with and work through them. And when we would finish with one, we would go to the next one. And through that process, we were able to address the issues that everybody had with regard to the litigation and come up with a resolution that fits everybody's needs. It's a unique deal, but we do have an agreement that does fit everybody's needs. So I know you're curious about the agreement and want to know about it. So we want to provide you that information, and each one of us will have an area that we'll talk to you about. Senator Coffey here will tell you about the legislative process, how the agreement was put together, how it will be enforced, and so forth. Stephen Greetham, the General Counsel of the Commerce Department of the Chickasaw Nation, will tell you about the nation's seat at the table and how the water has been designated or redesignated for recreation, fish, and wildlife, or a part of it has. First Assistant Attorney General Mike Hunter will talk to you about how the agreement retains the state's rights with regard to permitting and the rights retained by the Oklahoma Water Resources Board. J.D. Strong will talk to us about the science that was involved and the amount of time and effort that was related to the science and how it played an important role in this process. And then Jim Couch will talk to you about the needs of Oklahoma City, how those needs will be met, and the process that will take place. And then I will tell you about the lake levels, how they work, and some of the details about out-of-state transfers. So I'll start, and then we'll go down the row here and let each one of these experts tell you about the area that they are going, well, tell you about the specifics of the agreement in certain areas, and then we'll turn it over to you for questions and try to answer all of your questions. So first, let me address out-of-state water sales. The agreement does not promote out-of-state water sales at all, but it had to be dealt with for there to be a complete agreement. And so that issue was, it's very political, but it needed to be addressed. And so this is the process that has been set up. There will be a commission appointed, and the commission will consist of 5 people, 2 people from the tribe, 2 people from the state, and 1 independent appointed. If and when out-of-state water sales become legal, because they have not become legal now, or they're not legal now, this commission will look at the out-of-state proposal and then make a recommendation to the legislature as with regard to what should be done. The legislature will then act on that recommendation as they see fit. If there are proceeds from the sale of water, that goes into a special fund, and the fund can only be used for infrastructure within the state of Oklahoma, because the infrastructure is in bad shape in Oklahoma and everywhere, as we all know. There will be a formula to obtain those funds for infrastructure that sets forth various factors, such as the type of need, the number of people, and so forth. And southeastern Oklahoma, or towns or individuals in the treaty territory, will be given a 10-point advantage, or 10 points added to their application, which is significant because the numbers are around 70 when they total up, and they will also move to the front of the line. If there is a dispute, it's not resolved with regard to the distribution of the funds for infrastructure, then that dispute goes to the 5-person commission, and they make the decision about the dispute, and their decision is final. That's the basic structure of out-of-state water sales if they ever become legal. With regard to lake levels, there are designated lake levels. The storage pool that is in Sardis is from 542 feet to 599 feet. It's 297,200 acre feet. The agreement provides basically that Sardis stays at 595 or above for 92% of the time. But if there's a drought, and in drought conditions, if Oklahoma City needs water, it can be taken down below the 595. And there are specific provisions with regard to that. A part of those provisions consist of that the lake levels in the Oklahoma City area have to be down to a certain percentage, and then only can they go down to a certain amount in Sardis. Never below 589. Never below 589. So that's basically how the lake level system works. And you've got the 4 feet, the 595 to 599 that there's access to. Then the drought contingencies, but never below 589. So there's also the protection, as was mentioned, for in-stream flows in Sardis. And those are the basic areas that I wanted to talk to you about. And now I'll turn it over to Senator Coffey to let him tell you the process of putting the agreement together, how it will be enacted, and how it will be enforced, and the legislative process. Senator Coffey.
A little out of practice. Thank you for the opportunity to share with you today. While we are excited to share this news with you and the agreement that has been reached among the parties, this is not the end of the process. This still has to have the force of law, has to be enacted by Congress and signed by the President. And the reason for that are practical ones. This is in effect the same process as if it were a treaty or a compact, and to give it the force of law, we need to bring it before Congress and get them to enact it. Another reason that is necessary for why we structured it this way is the federal government is a party to this lawsuit as well. As trustee, they have represented the interests of the allottee interest, and to address the issues that are addressed in this agreement in allowing individual allottees to bring an action, it's also necessary to enact federal legislation. And another reason, not in any particular order, is that the state of Oklahoma currently has a debt obligation to the federal government for the building of Sardis Reservoir. This agreement finds a way, without any additional dollars, to satisfy the debt by the state to the federal government by assigning that interest from the 1974 storage contract to the city of Oklahoma City. They've already paid a payment to the state and to that was for part of the obligation. Once this is approved and becomes law, it would satisfy that issue, and by addressing that assignment, we give, along with the other issues that you're going to hear about today, a comprehensive settlement to the issues that are addressed in this 22 county area, with the intent, and I think the real benefit, and I just to take personal privilege, other people have said it, and I'll steal the words, it provides certainty for all the parties and individuals involved. It allows Oklahomans in all their respective capacities to move forward with certainty and help to grow this great state. It's been a privilege to be a part of it. Thank you.
Thank you, Senator Coffey. One thing that I thought I would also mention, out of the 297,200 acre feet of storage, Oklahoma City is permitted to take 115,000 acre feet, provided that it doesn't violate the lake levels and in-stream flows. The lake levels and in-stream flows trump everything, so I knew you'd want to know that number, so I give it to you. Mr. Hunter.
As some of you know, I've worked for Governor Keating for most of the last 15 years. And one of the neatest things about the governor was how he approached problems like this. Governor Keating would always say, let's decide what the best policy is, and then let's worry about the politics. So it was very refreshing when I got back here last spring and, with the direction of Attorney General Pruitt, got involved in this process. And I noted that everybody involved had that same attitude. If we can get the policy right, the politics will follow. So I wanted to memorialize that to you today. It's really an example of what happens when you focus on policy and recognize that the politics will follow if you get the policy right. It's been stated today that one of the most important principles, I guess, of this agreement was the acknowledgement that the state going forward will continue to, through the Oklahoma Water Resources Board, administer water resources, both in settlement areas as well as the rest of the state. So you could say that there are three principles to this agreement: cooperation, conservation, and certainty. And in many ways, I think this fulfills the certainty piece. Permitting will continue to be done through the Oklahoma Water Resources Board. All existing water permit holders are going to be grandfathered. And so going forward, the ability that we have to rely on that orderly system to manage water resources in the southeastern part of the state as well as the rest of Oklahoma just makes tons of sense. So it's been a real privilege to be part of this process. It, again, is, I would say to you, it's both an accomplishment of great leadership, good lawyering, and really good science, right, JD? Thank you very much.
Thank you, Mike. Next, Stephen Greetham, with regard to the nation's seat at the table in this agreement.
Thank you all. And to preface those comments, was taught long ago, particularly in the context of water, that when you have a conflict, you have threshold choice, litigate or negotiate. And a smart older lawyer once pointed out to me, if you rely exclusively on the litigation option, you might end up with a statement of your rights, but that's it. If you actually exercise the courage to go to the table and try to negotiate a resolution, you can end up with a statement of your rights, but you can also build relationships and come up with the resources necessary to build a better path forward. And each of the leaders in this process and each of their representatives has, to echo what Mr. Hunter just said, kind of really taken to task, kind of focus on the policy, figure out a way to work together, and we'll get there. And we're very happy today to be able to say that. When the nations first stood up and said stop on the proposed transfer of the storage rights in the Kiamichi, we indicated that fundamentally we were driven by an interest in protecting our sovereign interests, and that included ensuring that we would have a seat at the table on major water decisions. That's not a seat at the table in every water decision. We don't have an interest in micromanaging the state or individuals out there who actually drive our economy and are protecting our environment. But we do need, as sovereigns who are part of the fabric of Oklahoma, we need to be there. That is a very easily cast zero-sum game problem. How do you compromise sovereignty? How do you kind of split the baby as far as who gets what say? And it was a very challenging set of discussions. We found our solution essentially through mutual respect as far as who plays which role in that decision. The state, obviously, and General Pruitt said this as well, certainty in the permitting process is critical, both for purposes of the folks who are using the water and for the purposes of those who want to protect the environment and to protect the recreational and ecological values associated with non-consumptive use of water. We need certainty. Having the OWRB as the permit issuer is good for individual citizens, it's good for the Chickasaw and Choctaw Nation, and it's good for the state of Oklahoma. However, we need to have a mechanism for ensuring that the values that we want to see protected, those ecological values, recreational values that those living streams and lake systems down in southeast and south central Oklahoma rely on, we need a way to hold the state accountable. So the mechanism we've created is to establish a technical committee that will be convened for purposes of certain permitting actions, permanent decisions. That technical committee will then work together with the OWRB to develop a consensus hydrologic model. We will use, much like we did in this process, the best science available to make sure we're using the most objectively useful tool for measuring the ecological impacts of the proposed permitting decision. The OWRB will then use that tool to inform its decision and apply a standardized set of evaluative questions. To the greatest extent possible, we've made it entirely consistent with the state law process and substantive law, but we have the added benefit of that process where we can come together and vet the science together. OWRB will then make its decision. Judge Burridge already alluded to the Settlement Commission. And again, it's not legal today. Settlement agreement does not make it legal. If the state of Oklahoma ever changes its laws and chooses to allow out-of-state water use, the Settlement Commission will effectively act as the front door. And that is a collaborative state tribal entity, and it deals, and this is another point of clarification to make sure it's understood, we're just talking about water within the settlement area, just within the Chickasaw Choctaw Nation. So if water is proposed to move out of that area, this commission would be the front door, and its task would be to evaluate the economic and environmental impact of the proposal, and to basically frame the public discussion about what are we doing here, and then turn it over to the state legislature to do what it believes is in the best interest of the state of Oklahoma. However, if that transaction ever occurs, it would create resources not for the state, not for the nations, but to be plowed into a fund to support the desperately needed public water infrastructure enhancements that we need throughout the state. By being able to figure out a way to preserve the sovereignty of all of the governments that are involved in this, but to create that mechanism where they're able to come together to solve problems together, was one of the more challenging in its, aspects of this process, but it's also one that I think each of the principals deserves to be proudest of. Thank you very much.
Now, I don't know how this happened, but Jim's has been able to serve on both panels here. But Jim Couch, city manager, he wants to visit with you a little bit about how the settlement agreement works with regard to Oklahoma City and how it fulfills the needs that they have. Jim.
Thank you, Judge. Oklahoma City's had a good 15, 20 years. If you look back, we've had some growth in the area, and we're experiencing Oklahoma City and the Oklahoma City metro area, which we provide a lot of the water to, a growth rate of about 1.5% a year. And so we have good water resources at this point in time, but when you plan major water resource projects, you plan them decades in advance. And so Sardis is not for today. Sardis is for the future. We have to put a lot of capital improvements in the ground before we can take a drop of water from Sardis. It's going to be 15 years, maybe a little more, maybe a little less. We have to parallel the pipeline from Lake Atoka up to Lake Draper. It's about a $600 million project. We have to build a pipeline from a take point in the Kiamichi River where the water would come from. It's a place called Moyer's Crossing, and take a pipeline from there to Lake Atoka, about another $150 million. And so that infrastructure has to be in place before we can take water. So we're making a major investment to get the water we need in central Oklahoma, not for today, but for the future. And the agreement that we've struck is very uniquely done. I think we've covered some of the points, but it's such that we can take the water when there's adequate water or flowing water down in the basin and Sardis is full, and we can fill our lakes at that point in time. But there are great protections in place to protect Lake Sardis in the future, so it won't be drawn down to untenable levels, and we're keeping minimum stream flows in the Kiamichi River, both very, very important things as we went forward. And we're blending that or dovetailing that with a conservation program in Oklahoma City. And so with that, Oklahoma City and the metropolitan area should have adequate water for many decades to come. So, thank you.
One aspect of this agreement, or in one area that everyone looked at is the science, because the science needed to be followed, the science needed to be looked at, and the history of the basin needed to be looked at. And so J.D. Strong, the Executive Director of the Oklahoma Water Resources Board, is going to let you know and inform you the role that science played in this process and the role that science played in the terms and conditions of the agreement. J.D.
Thank you, Judge. Well, I'm the water nerd of the group, I guess. So I am here just to underscore the fact that everything that you have heard about this agreement could not have happened first without the vision and courage of the leaders that you heard from earlier today. That certainly is the thing that enabled us to get to where we are today. But also, what really lit the runway for us was science. At the end of the day, we were able to take the foundation of the recently completed comprehensive water plan and add to that a great deal of data and information and models and other hydrological tools that are necessary for us to make tough decisions. In the 20-plus years that I've been managing water, involved in water management in the state, we often find that that there can be a lot of emotional political reactions invoked from fears of the unknown, and the only way to really cut through those fears is to get rid of the unknowns, and science, data, scientific analysis is the way to do that. It's no exaggeration to say that we assembled some of the best scientists, hydrologists, modelers, and the best data and information that's been assembled in the state of Oklahoma with which to make the decisions that were made and ultimately resulted in the agreement that is before you today. Things like lake level management plans and how much water could Oklahoma City take without impacting tourism and recreation in Sardis Lake, and endangered species and other ecological needs within the Kiamichi River. All of those things require intense data and scientific analysis, and certainly all of the parties and all of the people that you see up here today are to be commended for bringing those resources to bear, never flinching about the fact that we would need to dedicate those resources to make these decisions possible. And I'm certainly proud of the result as a result of the great work that was done on the scientific side of things. So thank you.
I'd now like to see who has questions, and we'll try to answer them. Yes, sir.
Pat Craig, Capital Beat OK at the City Sentinel. I've heard a lot of key words, umbrella words, but I haven't heard cultural or historical. I presume that the tribes represented here had their interests represented in that respect, but I'm going to ask a question as I did 5 years ago about the Caddo Nation, the original Aboriginal people. Some of those hilltops, the lowland is now covered by water. Some of those hilltops originally belonged to the Caddo people. Is there any representation of the interests of the Caddo Nation in this agreement?
Well, Pat, you point to the seals, the hills that are behind us, but if you look at the 4 seals that are represented, it's an agreement between those 4 parties. The Caddos weren't a participant in this lawsuit. Whatever rights they possess as sovereigns, they have their own avenues to pursue enforcing whatever that means. But they weren't part of this agreement, and so that's why they're not part of this discussion today. Steve Greetham, I don't know if you...
Yeah, and what I'd add, virtually every Indian water rights settlement is structured around a set of waivers. The only waivers of claims in the settlement agreement are the claims of the Chickasaw and Choctaw Nation, or the United States acting as trustee for the Chickasaw and Choctaw Nation. No other tribe's water rights are affected. The settlement isn't precedent for any other Indian tribe's water rights. So the Caddo Nation, even the Wichita, who also have Aboriginal claims within the area, those claims stand today as they did 5 years ago.
So do you see any impact on the federal trustee role for what are now Western Oklahoma tribes with in-stream rights that flow down into the Red River or the tributaries?
No more so than any of the, when this is finalized, this will be the 30th Indian water rights settlement approved by Congress. This won't have any particular impact on those claims any more or less than others. What is important, though, is that now there is an Indian water rights settlement in Oklahoma, and that the parties have come together and demonstrated that it's possible. The state water plan since 1995 has made a priority of trying to figure out a path forward on some of these issues, but each tribe has to represent itself in its relationship with other governments.
I was just curious, as far as the technical committee and the commission that would meet in case of out-of-state or out-of-basin sales, are those two different groups? And who decides when the technical committee would get involved in a water issue?
Stephen, you want to address that, or JD?
First question, yes, they're different groups. The second question, there are, if you look through the settlement agreement, there are conferral thresholds, and if an application comes in that hits a certain conferral threshold, it's automatic. The OWRB still plays the primary administrative role, but then we look to the settlement agreement as to when different obligations trigger.
And both those groups would have a tribal nation driven.
Yes.
What is the city's outstanding obligation now on Sardis Lake? How much is still owed? And what is the procedure to pay that off?
The obligation to pay off the federal portion of Sardis, 27 million plus, and that was, the city made payment to the state back in 2010 on that. The remainder is after the storage right transfer is approved by the federal government, then the state is due another $15 million from the city of Oklahoma City.
And that takes care of the federal, like a pass-through?
No, that would, the federal obligation's been paid.
There's a future storage debt of about 51 million, but that future storage debt will never come due because what was designated as industrial and municipal water supply has now been designated under the agreement to recreation, fish, and wildlife. So it's going to be our position when we go to Congress that that indebtedness can never come due because of the designation of the portion of the reservoir. There's about 181,000 acre feet for local set aside and recreation, fish, and wildlife.
Senator Coffey, is there anything that will have to go before the Oklahoma legislature aside from any potential out-of-state sales?
That's it. The out-of-state sale issue is exclusively dealt with once prepped by the state legislature, but there's not a legislative action on this agreement. It'd be a federal act.
The agreement will be enacted as federal law and enforced in federal court.
I think it's been addressed, existing rights and permits, et cetera. I'd like to hear a little bit more discussion to the extent that we are protecting private property rights, water rights, and the permitting that already exists.
Yeah, it's been, I think, mentioned a couple of times, but certainly worth reiterating the fact that existing water rights are specifically affirmed by this agreement and protected. And the path forward for anyone that might want to appropriate water in the future is now a well-defined and clear path as well. The water rights permitting administration responsibility would remain with the Water Resources Board, and under certain circumstances that you can read about more specifically in the agreement, there will be additional technical conferrals with the nations involving any larger water decisions to remove water from the basins within southeast Oklahoma.
Yeah, when the lawsuit was filed, it was made very clear that the nations did not want to interfere with any existing permits that had been issued, and they have not and will not.
Whether or not it's called a draft, you get a copy of the agreement.
Yes, there's a website that's going to be live, waterunityok.com. There you go, and the settlement documents will be on the website for you to look at.
And the website's live now.
Yeah, just yes.
Is there any idea when U.S. government might approve this, how long it'll take to go through Congress and be signed by the president?
Well, the senators and representatives have been talked to. We made a couple of trips out there. They support the agreement, and so we're hoping that maybe the lame duck session, that we would get it passed. But if we don't, everyone still supports the agreement, and it'll just go forward until it is enacted as federal law.
Can I just add one?
Yeah.
And just given the federal government's trustee responsibility to the tribes, we've been working closely with the Department of the Interior and the Department of Justice. The administration generally has to bless the deal as well as it's going through the congressional process. So we've been working hard to queue that up. But this agreement right now is as among us, and that'll be part of the federal process.
We will make an effort and are hopeful that it will be done within the lame duck session.
Right.
Do you have any sense of BIA's position? What they'll say to the White House?
Interior's been very supportive. There are the devil's in the details, and they look at it closely with respect to their fiduciary obligations to all tribes. But they've been very supportive of the approach we've taken.
There's been meetings with Interior and Justice, several meetings with them, and so they are very familiar with the agreement and supportive of it. Somebody in the back? Yes, ma'am.
Obviously by January 21st, we'll have somebody else in office that will have their signature on this. Any concern about either of those two parties not agreeing to this or not putting their signature on it?
Well, we'll have a new administration, and, their staffs may have to be, educated with regard to the agreement, but we think that regardless of who is there, that it will be enacted.
We've largely been working with professional staff who typically exist in one administration and then exist in a subsequent administration. So there's going to be some continuity there, but we'd certainly rather have it done before the conclusion of this administration and this Congress.
In the past, the 29 prior agreements you referenced earlier, has that generally been the Congress, as they do on some such things, but not 100% of the time, would go along with the home state delegation's inclination?
Generally,
It's been the case,
yes.
the 29 previous accords going back a long time.
Yes. The federal interest is going to primarily boil down to money. What is the federal price tag on the agreement? What obligations does it impose on them? Operational requirements, liabilities in the future. But if the home delegation is supportive, supporting complex problem solving, believe it or not, ends up to be a fairly bipartisan issue. So whoever's president January 21st, I think they're going to be supportive.
The biggest impediment to these kind of deals is the budget impact. And because I think we're able to represent conclusively that there is none based on the terms of the agreement, that's going to be a real benefit in terms of our ability to move this thing with dispatch.
Two more? Okay. Yes, sir.
Yeah, JD, there's some outstanding applications for water on Sardis, as you know, and I was just wondering, could you address that? For example, Clayton Chamber of Commerce has an outstanding application that's never been considered by the board.
Yeah, the agreement says that those will be dealt with as they need to be dealt with under existing state law, and so it'll just fall on us at the Water Resources Board to take care of any applications that may still be in the pipeline.
Thanks, JD.
If they're in the pipeline, are they grandfathered? Not necessarily. It's a matter of state law how we handle applications that have yet to be processed, and the laws and regulations are pretty specific about how we treat them based on the specific facts given each application.
And one point of clarification, too, with regard to permitting, the settlement agreement doesn't result in Oklahoma City, once we sign it, having the permit in hand. The settlement agreement resolves the nation's objections to the OWRB's proceeding under state law to handle that permit, subject to the conditions we negotiated. So those pending permits, the ultimate resolution of this, that's going to be driven by what the rules are.
Thanks. I think the people in southeastern Oklahoma would like to know that, so I appreciate it.
All right.
Just a couple more things. As was pointed out, you see it right here, waterunityok.com. That is the webpage. It is fabulous. It has lots of material. It's very, very well done. Secondly, some of these folks will be able to stay and do some one-on-one if you would like afterwards, depending upon their time, and you're welcome to come forward and talk to them. And finally, I certainly want to thank the Oklahoma Hall of Fame. I think it's appropriate to have this historic meeting in this historic structure. Thank you and good afternoon.